Imagine finding out that a house you helped pay for, managed as a landlord, and essentially kept alive with your own money, was sold without you even getting a phone call. The proceeds? Gone. Your name was never on the deed. And legally, at least on paper, you never existed in that transaction. That is exactly what happened to one person in Virginia, and what they did next could change everything. This is a story about family, real estate, broken trust, and a legal fight that is still unfolding. If you have ever gone in on a property with a family member, or if you have ever contributed financially to something without getting your name on the paperwork, you need to hear every single word of this. Let's set the scene. It is 2016. A man and his brother decide to purchase a home together in Virginia. The price tag is $300,000. The plan is simple. They are sharing the investment, sharing the responsibility, building something together. But there is one significant detail that would later become the center of everything. Only one of them, the brother, had access to a VA home loan. For those unfamiliar, a VA loan is a mortgage benefit available to eligible military veterans and service members. It comes with favorable terms, often no down payment, no private mortgage insurance, and competitive interest rates. The catch is that the loan is tied to the veteran's entitlement, and typically, the primary borrower on a VA loan must be the eligible veteran. So the brother used his VA loan to purchase the house. His name went on the loan, his name went on the title. The other brother, the one telling this story, contributed financially from the very beginning, paying into the mortgage, being part of the arrangement, but his name appeared nowhere on the legal paperwork. No deed, no loan, no title. For most people, that might seem like a minor administrative detail between brothers, a handshake understanding, family trust. But in real estate, and in the eyes of the law, paperwork is everything. For years, this arrangement held together. Payments were made, the house existed, and then life happened, the way it always does. By 2022, the brother who held the VA loan lost his job. Income dried up, the mortgage still had to be paid. And so the other brother stepped in completely. He took over the entire mortgage payment, every single month. He was not just contributing anymore, he was carrying the full financial weight of a property that was not legally in his name. Think about what that means for a moment. The legal owner of the home was not paying for it. The person with no legal claim was keeping it alive. Then in 2023, the situation evolved further. The contributing brother started renting out the property. He became the de facto landlord. He found tenants, managed the rental, handled the day-to-day responsibilities, collected rent, and dealt with everything that comes with being a property manager. He was running the show on a property he had no legal ownership of. From a practical standpoint, he was the owner in every way, except the one that actually matters in a courtroom. And then 2024 arrived, and with it, a breaking point. The two brothers had a major falling out. Communication collapsed. The relationship deteriorated to the point where they were no longer speaking. And in that silence, something happened that the contributing brother had no idea was coming. His brother listed the house, sold it, walked away with the proceeds. No warning, no conversation, no split, nothing. When the contributing brother found out, the house was already gone. Sold in early April of 2024 for $475,000. The original purchase price had been $300,000. That means the property had appreciated by $175,000 over 8 years. A significant amount of equity had been built, equity that the contributing brother helped create through years of payments, management, and financial sacrifice, and he received none of it. Let that sink in. He paid the mortgage when his brother could not. He managed tenants. He kept the property cash flow positive. He did the work of an owner. And when the sale happened, he was invisible. So what do you do when this happens? What legal options even exist when your name is not on the title, not on the loan, and not on any official document, but you have years of financial contributions, records of mortgage payments, and a clear pattern of conduct that shows you were a co-investor? This is where things get genuinely interesting from a legal standpoint. And this is where the contributing brother started fighting back. In late April of 2025, he retained a civil litigation and business and real estate attorney. A demand letter was sent in June of 2025. The legal process is now officially underway. But what are the actual legal theories that could apply here? Let's break them down because this is where you, as a viewer, can really learn something valuable. The first and most powerful concept is called a constructive trust. When someone holds legal title to property, but doing so would be unjust because another person has a rightful claim to it, a court can impose what is called a constructive trust. Essentially, the court says the legal owner was holding this property in trust for someone else, whether they intended to or not. In Virginia, courts have recognized constructive trusts in situations involving oral agreements, family arrangements, and unjust enrichment. If someone can show that they contributed financially with the expectation of sharing in the property, and the legal owner sold it and kept all the money, that is a classic setup for a constructive trust claim. The second concept is unjust enrichment. This is exactly what it sounds like. One person has been enriched, financially benefited, at the expense of another person, and it would be unjust to let them keep that benefit. In this case, the brother who held the title received hundreds of thousands of dollars in sale proceeds from a property that the other brother had been largely financing. That is a textbook unjust enrichment argument. Third is an implied or resulting trust. When money is contributed toward the purchase of property, but title is held in someone else's name, courts sometimes recognize what is called a resulting trust. The idea is that the law presumes the legal title holder was holding the property for the benefit of the person who actually provided the funds. This is especially relevant because the contributing brother was making mortgage payments for years, including covering the full mortgage when his brother was unemployed. Fourth, and perhaps most straightforward, is a breach of contract or oral agreement claim. The brothers had an understanding, a shared investment arrangement. Even without a written contract, Virginia courts can enforce oral agreements in certain circumstances, particularly when there is substantial evidence that the agreement existed and that one party relied on it to their detriment. Years of mortgage payments, rental management, and financial contributions could serve as that evidence. Now here is the honest reality check. These cases are not easy. The absence of documentation is a genuine problem. No written agreement, no ownership stake on the title, no formal record of the arrangement. These things hurt your case. The brother on this side of the dispute has an uphill battle, and anyone in a similar situation should understand that. But uphill does not mean impossible. What helps this case is the paper trail of financial contributions. Bank records, payment histories, evidence of who was actually paying the mortgage, documentation of rental income and management. All of that tells a story, and courts in Virginia are capable of hearing that story and recognizing when someone has been genuinely wronged. So what can you take away from this? If you are ever in a situation where you are contributing financially to a property, especially one that involves a family member, get your name on the paperwork. This cannot be stated strongly enough. An oral agreement between brothers, between friends, between any two people, means almost nothing when a legal dispute arises. What matters is what is documented, recorded, and signed. If you are already in an arrangement without your name on the title, consult a real estate attorney immediately. There may be options to formalize the arrangement through a co-ownership agreement, a deed amendment, or some other legal mechanism before a dispute ever arises. If you contributed financially to a property and were shut out of the proceeds after a sale, do not assume it is over. Depending on your jurisdiction and the specific facts, you may have legal options including the constructive trust and unjust enrichment claims we discussed. But time matters. Statutes of limitations apply. The sooner you speak with an attorney, the better your options. Keep records of everything, every payment, every text message, every email, every agreement, even informal ones. These records become your evidence if things go wrong. And finally, if you are using a VA loan to purchase property with someone who is not on the loan, understand the risks from the very beginning. The VA has strict requirements, and the person whose benefit is being used is the one with the legal power. That creates an inherent imbalance that needs to be addressed in writing before a single dollar changes hands. The person at the center of this story did the right thing eventually. They got an attorney, they sent a demand letter, and they are pursuing legal action. Whether they recover anything is still to be determined. But the lesson they are living through is one that could have been prevented with a simple conversation and a signed agreement in 2016. If this has happened to you, if you contributed to a property, supported a mortgage, managed a rental, and then found yourself on the outside when the money came in, do not wait. Speak with a real estate or civil litigation attorney in your state as soon as possible. Your situation may have more legal remedies than you think. And if you want to keep seeing real legal situations broken down in plain language so you know your rights before something goes wrong, subscribe to this channel. New videos go up regularly, and the next one might be exactly the situation you or someone you know is dealing with right now.